We have about 15 minutes left for question and answer.
I wanted to start off initially and tell you that if you ever get in a situation where a CPRE award is going to be awarded, you're going to approve one, I would like for you to consider the Searle Center.
Henry was very upset with some of my conclusions.
You need to get that into the paper. The address is on the back of the program. I'd also want to start off with a question for Chris. We do have a few judges from Minnesota here, and the Minnesota AG has been very active on this front dealing with the National Arbitration Forum. I think if you could just take a couple minutes and let them know what has gone on up there and see how that relates to what you've done.
Sure. I mean, the Minnesota Attorney, and I mean, it's sort of relevant to the broader debate as well. This summer, the Minnesota Attorney General filed suit against a very prominent and as far as caseload goes, very large administrator or provider of debt collection arbitration services, the National Arbitration Forum. And the allegations were that essentially it was the NAF was committing fraud by touting itself as independent when in fact, and the facts are a little complicated and I don't think they've ever been proved, they were just alleged, but that a subsidiary of the NAF was invested in by a hedge fund that was also investing in a law firm or a debt collection agency that was bringing lots of claims before the National Arbitration Forum. So that basically it was all one big group of people trying to collect money from consumers. The NAF settled within a week, basically shutting down its declining to take further consumer arbitration cases. It actually is continuing to, at least it was, to resolve the ones that were before it. And so, I mean, who knows what you can read into, and I guess it's also been subject to a number of class actions being brought now alleging fraud on its part in what was going on. The implications for our study implications, I mean, we didn't study the National Arbitration Forum. We haven't looked at the National Arbitration Forum's cases at all. A lot of the numbers, the Star Wars example, for example, is Elizabeth Warren responding to a public citizen study of the National Arbitration Forum cases based on some publicly available data. The numbers are roughly the same as the state court cases for what it's worth, but we haven't said anything about the National Arbitration Forum. It does suggest to me that there's sort of an open question about whether this is a good thing for consumers necessarily. I mean, if you're not before the National Arbitration Forum and you're in court instead, the consumers still lose most of the time. So whether it accomplishes what was being set out for is at least an open question.
Can I ask Henry a question? Sure. In my career, I've gotten to know two directors of the Bureau of Consumer Protection at the FTC. One was Bill McLeod during the Reagan years, who was extremely conservative. The other is the current head of it, Stephen Vladeck, who is a former Nader Raider and is quite to the left. Can we really say there's a generic FTC policy? I just assume that these two individuals would have very different perspectives on what FTC policy should be.
Well, the policy, I mean, has not changed, and it's a lot of these decisions that are made to pursue these cases are at a fairly, professional staff, civil service level.
It's not a political policy.
Well, there may be a few that will be brought that way, and certainly the policy could change, and they actually don't have to issue any regulations to change what they do. I mean, what's currently viewed as the policy was a letter that Jim Miller, who was then chairman of the FTC, wrote to Dingell articulating what the standards were for unfair and deceptive actual practices, and that's cited all the time by the FTC and by commentators on this area and so forth, and that's survived the entire Clinton administration, and it may not survive the Obama administration, but in terms of, I'm glad you asked that question, because when we did our shadow FTC, one of the things we tested for was whether or not we were getting kind of a partisan effect in terms of the voting on these things. And we had a lot of 4-1, 5-0 type votes on these cases. It wasn't like party lines determining the outcome of these. So we were concerned about that also as a check in terms of kind of some ideology of people's political backgrounds having some impact on that. It could change, and if it changed, I would expect it to go towards a more viewed as consumer-friendly position, which I think the study right now does not get to the ultimate question of whether or not these actions benefit consumers. The next step is to apply what in antitrust law is referred to as the consumer welfare standard. Seems like we ought to have a consumer welfare standard in consumer protection litigation as well. And some of that can deal with looking at the impact on prices and so forth. And we're trying to collect data which will let it try to see if we can tease out some impact on prices in different enforcement philosophies across states. There are a lot of these cases. They impose a lot of costs. We expect to have an impact on price at some point. And that's the next step in the project, actually.
Gentlemen, this was a very exciting program, and I am grateful for the invitation to be here. It's a lot of fun listening to statistics.
Yahoo!
Christopher's analysis tends to show, if you want to read it that way, that we need regulation to deal with the bad actors, to bring them up to the standards of the AAA, which I agree with you is a very responsible and able organization. But by not focusing on the bad actors, you give us a distorted view of the facts relating to arbitration. Henry had a terrific presentation, and of course, as he pointed out, the data could tend to show that the FTC is not active enough and that you need supplemental remedies at the state court level. I do think he should pause before he looks down on state court judges and suggest they cannot handle that type of cases, however. And Martin did not tell what to do with the money if you don't have people. Of course, you could propose to state legislatures and the Congress that any money left over from a trust or a class action should escheat. No one's done that. And as you say, the system of Cypre has been around for a long, long time. So you'll have to find a political solution. Well, telling the judges that they shouldn't participate in an improper application of their power doesn't tell them what to do with the money.
That's a fair point. What I should have added was my proposed solution, which is simply to include as part of the certification process a judgment as to whether will be meaningful relief provided to those who've been injured. And in those cases, much of the CyPRE awards, or CPRE awards, are ex ante, as I refer to them. In other words, even before they've given an opportunity for claimants to file, they set out the money for the CPRE award. So that means they know from the beginning that these people are just a cardboard cutout of a class. So the way to avoid it is simply not to certify the class in the first place, so you don't even have that problem.
If I can just make one comment on the arbitration front. I mean, it's a fair point that we only focus on the AAA, which is generally seen as a good actor. For what it's worth, the proposed legislation, at least the most prominent one, would get rid of all consumer arbitration, both with bad actors and good actors. So the implication we draw from it is you need to make sure and be a little more narrowly tailored if you're going to make legislative response or do legislative responses to sort of focus in on the bad actors rather than just grouping everyone together. And for what it's worth, there are other ways of doing this, such as unconscionability. And we don't take a position on, and we don't have data on, whether the extent to which you need even legislation to deal with the bad actors.
A data question for Christopher.
Hold on. I got to get to respond to the one comment about mine also. Just very quickly. Judges are very important in this role, and I didn't mean to be taken as looking down on state judges and their ability to get this, but our data does suggest that to the extent that you think state judges think that that in the best cases that we found, that they are furthering the interest of what's our national policy on consumer protection is, they're wrong. All right, so that doesn't mean, that may be what the statute requires them to do, but in the statutes, when the statutes are very vague, it's clear that judges are really important to making these things work right. If the statutes are vague and the judges basically let anything fly, then we get a lot of litigation. There are some states that have the vague standards but don't have a lot of litigation. So and what's going on in those states, my guess is the judges have interpreted the statutes fairly narrowly and probably consistent with the FTC. Okay.
Question for Christopher on the data. The AAA data would all be contested cases, both sides appearing and arguing. The state court data for collection actions, oftentimes those are default cases. Do you compare state court collection cases which were actually litigated, both parties appearing, or do you also include those that are defaults?
We do both, and we separate them out. Some of, although a smaller percentage at least of the main sample of AAA cases we looked at, there are some that were not contested, that were ex parte awards that were resolved with basically on a default basis, although a lower percentage of the court cases. When we limit our analysis simply to contested cases, it actually becomes more pronounced. I don't have the numbers off the top of my head, but that the win rate, the consumers win more often in arbitration, in contested cases in arbitration, than they do in contested cases in court, even more so than the uncontested cases. So again, that strikes me as actually a good test of sort of biased decision making, is you try to sort of not ignore, but sort of control for whether someone actually shows up, because that obviously is a very important part of the reason businesses win so often, is that the consumers just don't show up in a lot of these cases. But even once you do that, consumers tend to do better in arbitration than in court, in the cases we looked at. We try to control for as much as we can. We can't control for everything, but we do control for that.
A couple observations before we end today. As it relates to the two studies that Professor Butler and Professor Drahosel talked about, these are both large-scale empirical studies. We have a board of overseers for the Searle Civil Justice Institute that adopted a research protocol. That research protocol was followed in respect to both those studies. In addition to that, both studies were subjected to peer review by a panel of academic experts. So we feel very good about the quality of the studies and the key findings that are embedded in those studies. I would encourage you to read, at a minimum, the executive summaries that are contained in the preliminary reports. I think you'll find the key empirical findings to be very striking, and then some of the discussion about potential policy implications to be very interesting. One of the things that strikes me when I listen to the questions and the dialogue is that I think what we uncover is that when you study the facts, the world is much more nuanced than it appears when you give out sound bites. And so the soundbite that, wow, if businesses win 90% of the time in consumer arbitration, it must mean that arbitration is biased. And then you sort of study it, and even if it's just a single provider, you find out that the world is much more nuanced. The facts make the world more complicated, and so policy and judicial decisions have to reflect that complexity of the real world. The same thing is true of both the Consumer Protection Acts and the Cyprea Awards. You'll hear sort of the simple statement of why this is a good thing or a bad thing, and then the facts suggest that a world that is much more complicated and much more nuanced. And so if there's anything that I think that the Searle Civil Justice Institute is contributing to civil justice discussions is, I think the notion that when we hear somebody say, here's how we're going to fix the world, to slow down, to study the facts in a systematic and rigorous way, and oftentimes we're going to discover that we need much more sophisticated solutions than those proposed by one side of the bench or the other, or bar or the other.
Okay, I've got a couple closing comments before we thank the panel. One is that we have a reception right outside, and you're all welcome to join us, just out in the area where in the atrium area. Also, we practice the national park rule here. What you brought in to the room, please take out with you and throw it away. It makes it a lot easier on the staff around here to help clean that up. And second of all, we start back tomorrow morning. Breakfast is from 7:15 until 8. The program will start promptly at 8. Jeff will be moderating that first session. He's not going to move between now and then. So we look forward to seeing you outside. Please join me in thanking this great panel.